I'm here with lawyer Geneviève Grey, who is part of the legal challenge of Bill 21. Thank you so much for joining us, Ms. Grey. What exactly was your role?
So I represent interveners QCGN and CHRC, and we are interveners on the side of those contesting Bill 21, now the law. And so we prepared our arguments in Superior Court and in the Court of Appeal. We pled our arguments. It was not specifically me, but Matt Julius Gray who pled those arguments. We received the judgment today, so we got a chance to look at it. We're very disappointed by the results, unfortunately, but we look forward to bringing this to the Supreme Court of Canada.
What exactly stuck out to you in this judgment? What did you make of it?
Well, I think we were disappointed on the Section 23 decision because they reversed the first instance, the Superior Court findings. So that was very disappointing. But we plan to. I think that also opens it up to an argument in front of the Supreme Court of Canada, since there were two decisions that were slightly different. So hopefully we'll be able to present our arguments. It was disappointing to see that, but there's very little you can do, right? I just digested hundreds of pages of a decision. What stood out to me was of course the fact that we lost, which is always disappointing, but it's just a step. It's obviously the fight is not over yet, and we plan to continue to fight to make sure that we can, protect minority rights. So that's what we want to do.
And what grounds do you have to go to the Supreme Court?
Well, it's not easy. So there's always I think there's, in a broad sense, this is a very long judgment. It's an important judgment. I think that because there were different reasons given in first instance and in appeal, that opens you up slightly to a Supreme Court of Canada intervention, in the sense that these aren't two judgments that were identical. These are both long judgments. So I do think that the Supreme Court of Canada will want to have their word on this, their final word, and it is a unique situation. So that, in a broad sense, opens us up. Now, there are certainly arguments that I saw that, off the top of my head, that I think we could make in terms of factual findings versus findings of law that open you up to an appeal. And I think there's arguments on the merits of the case that certainly open it up to being at least of interest to the Supreme Court of Canada. So even if they might not necessarily change things, which who knows, I can't pronounce myself on that, I think they will want to look at it. It's such an important decision that I think they will want to have their say.
Thank you so much for joining us, Ms. Grey.
Thank you for having me.
In Montreal, Alyssia Rubertucci, City News.